Recording. Hello, friends. I'm Dr. V. Srinivas, Assistant Professor, Department of Commerce, PB Siddhartha College of Arts and Science, Vijayawada. Today's discussion topic is essential elements of a valid contract. What is a contract? Section 2H of Indian Contract Act 1872 defines a contract as an agreement enforceable by law. Section 2E defines agreement as every promise and every set of promises forming consideration for each other. Section 2B defines promise in these words when the person to whom the proposal is made signifies his assent thereto the proposal is said to be accepted. A proposal, when accepted, it becomes a promise. A proposal, when accepted, becomes a promise. From the above definitions of promise, it is obvious that an agreement is an accepted proposal. The two elements of an agreement are offer or a proposal, acceptance. So in an agreement, offer and acceptance of that offer. What agreements are contracts? There is a statement, all agreements are not studied under the Indian Contract Act, as some of them are not contracts. Only those agreements which are enforceable at law are contracts. The Contract Act is the law of those agreements which create obligations, and in case of a breach of a promise by one party to the agreement, the other has a legal remedy. Thus, a contract consists of two elements: an agreement, legal obligation. That means a contract, a valid contract, the base is an agreement and legal obligation, which should be enforceable at law. However, there are some agreements which are not enforceable in a court of law. Such agreements do not give rise to contractual obligation and are not contracts. That is, social obligations or social obligations are not enforceable in the court of law. Example, A invites B for a dinner in a restaurant. B accepted it, the invitation. On the appointed day, B goes to the restaurant. To his utter surprise, A is not there. A is there but refuses to entertain B. B has no remedy against A because it's a social obligation. In case A is present in the restaurant but B fails to turn up, then A has no remedy against B. These are all social obligations. Social obligations are not enforceable in the court of law, only a legal obligation. What are the essential elements of a valid contract? We have seen about two elements of a contract: an agreement, legal obligation. Section 10 of the Act provides for some more elements which are essential in order to constitute a valid contract. It reads as follows: all agreements are contracts if they are made by free consent of parties competent to contract. That means ability to enter in contract, lawful consideration, lawful object, not declared as a void. These are some of the essential elements of a valid contract. These are the list here. Valid contract. These are the essentials of a valid, and there is a summary of this. All this agreement, intention to create legal relationship, free consent, parties competent to contract, that is capacity of parties, lawful consideration, lawful object, agreements not declared to be void or illegal, certainty of performance, certainty, possibility of performance, necessary legal formalities. Agreement. As already mentioned, to constitute a contract, there must be an agreement. An agreement is composed of two elements: offer and acceptance. The party making offer is called offeror. To whom the offer is made is known as offeree. Thus, there are essentials to be two parties in to an agreement. They both must be thinking in the same, that is consensus ad idem. So when the parties come into an agreement, the parties should understand the subject matter. That is, the way A thinks, in the same similar way that B has to think. That is, there must be a consensus ad idem among the minds of this between the parties. Intention to create a legal relationship. There should be an intention on the parties to create an agreement, a legal relationship, not in a social relationship. An agreement of purely social or domestic nature is not a legal contract. Example: a husband agreed to pay £1,000 to his wife every month when he was abroad. As he failed to pay the promised amount, his wife sued him in the court of law for recovery of the money. Held that this she could not recover as it was a social agreement and the parties did not intend to create any legal relationship. This is a Balfour versus Balfour case law. Free and free consent. The consent must be free. Contracting parties must be free from all these forces without any force. Consent of the should not be obtained by misrepresentation, coercion, fraud, undue influence, or mistake. The consent is obtained by any of these laws, then contract is not a valid contract. Parties competent to a contract. The parties to a contract should be competent to enter into a contract. According to the section 11, each person is a competent to contract. If he is an immaturity, a minor is incompetent to enter a contract with a minor is absolutely one. The sound mind, that is the ability to understand the subject matter, is not a disqualified from contract by any laws which is subject. There may be a flaw in capacity of the parties, drunkards, lunatics. These are all these people are incompetent to enter into a contract. So if a party to a contract suffers from any of these flaws, the contract is unenforceable except in case of exceptional circumstances. Lawful consideration. A contract without consideration is absolutely void. Consideration is essential, something in return. The agreement must be supported by some value, something that something is called, it's a consideration. Each party to the agreement must give a promise, something or receive something or a promise in return. Consideration is a price for which the promise of the other is sought. However, this price need not be in the terms of money value, and a promise is also enough. In case of a promise is not supposed to be consideration, the promise will be a nundum factum. That means we are a mere promise, it's not enforceable. Moreover, consideration must be real and unlawful. Unlawful consideration is it's invalid. That is a valid. It's not a valid part. Lawful object, subject matter, or object of the agreement must be lawful, and not one which the parties approves. Agreements which are declared to be void, expressly illegal, void contracts. Such cases, even an agreement possesses all these elements of a valid agreement, but agreement will not be enforceable because of some declared as a void contract. Certainty of meaning. The meaning of the agreement must be certain or capable of being made certain. Otherwise, the agreement will not be enforceable at law. Possibility of performance. The terms of the agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. For instance, A agrees to discover a treasure by magic. Later, the A failed to deliver his promise, but it's not possible to file a suit because it's not possible to find to discover a treasure by magic. Such agreements cannot be enforced. Necessary legal formalities. A contract may be oral or in writing. If, however, a particular type of contract is required by the law to be in writing, it must comply with the necessary formalities as to writing, registration, and attestation if necessary. These legal formalities are not carried out, then the contract is not enforceable at law. Thank you. Thank you all for watching this video. Thank you very much.